Morning, good afternoon. Be seated, please. We're here on a rescheduled special hearing. Case number 18-30694, United States versus Cuff. I'm going to dispense with the usual formalities because I know you're well aware of them. Mr. Larson, good afternoon.
Good afternoon, Your Honor, and may it please the court. When this court granted the certificate of appealability in this case, it asked the parties to address three very specific questions which are at the heart of this proceeding. The first was whether the breach of a plea agreement is a claim that can be asserted in the first instance in a 2255 motion, to which we respond, yes, when there is no alternative. And there's no alternative because the breach occurs either after or first becomes known after the district court has lost jurisdiction and the time for filing an appeal has run. And so the only avenue available to a litigant at that time would be a 2255 motion back in the district court. It would be illogical to think that the government could breach a plea agreement after sentencing and after the time for the filing of a notice of appeal, but a defendant is without a remedy because this type of claim could only have been raised on direct appeal.
Well, if he was without a remedy, why did he raise it in his direct appeal?
He did not raise it, Your Honor.
He alluded to it.
He alluded to the fact that there was a separate prosecution in Texas at that time. I was the counsel on that direct appeal, and it was alluded to, but it formed one of the 7 car factors as to why Cuff should be permitted to withdraw his plea of guilty in the district court. Remember that the record at that time looked very, very different from how it looks now. All those pleadings were sealed at that time. There was no evidence, much less 4 separate instances of evidence, that the government had directly attempted to conceal the fact of that prosecution. None of that became known until the 2255 proceedings were filed and the records began.
Well, you saw the date of the indictment, didn't you?
We saw the indictment after the notice of appeal.
I understand that, but the indictment was what, December of 2011 or 12?
The indictment was ostensibly unsealed in January.
Right, but
and
there's always a date on the indictment.
There is a date on the indictment, and what was available at the time of the appeal, the notice of appeal is filed. The arrest warrant is actually served on August 28th, 2012. And this is after both notices of appeal had been filed.
Well, I don't really understand. I mean, you're in the midst of doing your appeal. I understand you wanted to withdraw the guilty plea, although to be honest with you, I have not read the prior appeal judgment or opinion, but you knew that an indictment had in fact been dated nearly a year previously at that point, and you weren't aware of it, and nobody had told you about it, or Mr. Scans, and therefore, I think it would have been a reasonable inference that something was kept from you.
Absolutely a reasonable inference, but Your Honor, I would urge you to think, but what would the record at that point on appeal look like to this Court of Appeals? First, there had been no objection in the district court, so this court would actually have the right to disregard the issue under very strong case law from this court.
You didn't cite a case. What's your best case for that proposition? I don't actually recall coming up with having a case like this with this type of new evidence coming in after the sentencing.
I don't recall any case like this before, Your Honor, because I've never been in a case where the government deliberately concealed a prosecution for 8 months until after sentencing. It's clear that that was the government's intention, and everything that is now available in the record from the Texas proceeding indicates that the government deliberately and intentionally concealed the fact of that prosecution until after the sentencing in the Louisiana case.
Well, suppose that provided cause for a procedural default. Then you'd have to argue prejudice, right?
Absolutely, Your Honor. And there are actually 4 forms of prejudice in this case that are a result from the government's intentional misconduct. The first form of prejudice is that Cuff had to defend for 2.5 years against a prosecution of which he was not aware at the time he entered his plea of guilty in Louisiana. Second, he was prejudiced by the fact that his attorney Carnes was unaware of this prosecution and didn't have the opportunity to basically negotiate in the first case a global resolution of all of the charges against Cuff. The third prejudice comes in the form of that all of the evidence in the Texas case was offered at the sentencing in the Louisiana case. The prosecutor in the Louisiana case, Luke Walker, specifically said, I'm going to introduce evidence from Texas that was seized pursuant to a search warrant in the sentencing. So Cuff actually faced the possibility of being prosecuted and sentenced twice for the same conduct, which would have violated double jeopardy.
Well, I'm not sure that would have been technically the case, but anyway. Now, was he indicted in, is this because the abuse in El Paso occurred on federal property? Is that why it would have been a federal indictment?
My understanding, Your Honor, is that it was a federal indictment, not simply because it was on federal property, but because of the interstate commerce and the possession of materials that had been transmitted in interstate commerce. It was not, jurisdiction wasn't based just on where the property was seized, is my...
Yeah, but the Western District prosecution.
Yes, that's what that as well.
Oh, because he had made videos and uploaded them to, okay.
Yes. And so what we have is an instance, even assuming that, and I think, to go back to the original point, Your Honor, I think Massaro absolutely permits this type of claim to be raised in the first instance in a 2255 proceeding. There are 3 cases from this court in which a claim could be raised initially for the first time in a 2255 proceeding when it hadn't been raised on direct appeal. The court's second and third questions about cause and prejudice, I would conclude with one fourth point regarding the prejudice prong. And the fourth point is that Cuff's attorney was deliberately kept in the dark as to the full scope of the charges against Cuff.
I'm not trying to defend the government's conduct here, but this man is in prison for life.
Yes.
And the only prejudice I can see, other than the fact that nobody should be treated shabbily by the federal government, is this allegation that he had to, quote, defend for 2.5 years. It's not at all. Why did he have to defend the Western District charges at all?
Well, because, Your Honor, at that time, it was clear from the record that Mr. Cuff was not competent to stand trial. Those charges in the Western District...
Why couldn't his client have just told the government, we're out of here, you do what you want?
Well, he certainly could have, Your Honor, but that's not consistent with a defense attorney's obligations to represent a client. If a client is not competent to proceed to trial, how can you tell the government, do as you will? Because essentially you're conceding that your client should be sentenced to life imprisonment a second time. That is...
Well, life is life. I understand the theoretical quandary. I do not understand it from a practical standpoint. Who was the federal judge?
The federal judge in the Western District of Texas was Judge Cardone, and the judge in the Western District of Louisiana was Judge Hicks. The prejudice to what has happened. Essentially, what we would be saying is if we did not, and remember, we're before this court, Your Honor, only on the question of whether Cuff was entitled to a hearing in the district court on his 2255 motion. That's the question before the court. We're not actually here to resolve the issue of whether habeas relief should be granted, although I believe it's certainly justified in this case. We're here to determine whether Cuff, based on the allegations made in his petition, was entitled to a hearing in the district court. And I think if you look at the plain language of 2255, which requires that the pleadings and record on file conclusively establish that the defendant prisoner is not entitled to any relief, that standard has easily been satisfied regardless of which of the questions you answer yes to.
The other aspect of this, of course, is that even if we were to grant you relief and allow you to go forward on the idea that your guilty plea should be vacated, you cannot possibly argue that he would not plead guilty again.
Yes, actually I can, Your Honor, because he's not competent to proceed. This is a man who was not...
He's going to be locked up forever one way or another.
Well, yes, but in one instance he would be in a facility suited to receive him where he could be treated for his mental condition instead of a maximum security federal prison. And
where's your... I know you allege this, that he was decided to be not competent. How come that just suddenly appeared after the sentencing? That did not suddenly appear after the sentencing, Your Honor. About the same time. No, in fact, it was taken, Judge Hicks took note of it at the time of the plea colloquy when he pled guilty, because he called a conference in chambers, and it's on the record, that he, at that point in time, ordered a mental examination of Cuff. That's after the fact. There were 6 examinations of Cuff between the time he pled guilty and the time he was sentenced. Motions to withdraw his guilty plea were filed, multiple motions with affidavits, expert witness reports, and things of that nature, all of which were denied by Judge Hicks. He simply denied them, flat out denied them. And so at that point, the sentencing went forward, which is when the direct appeal happened. And it was clear at that time, it was not long after his sentencing in the Louisiana case that he was, in terms of time, that he was found incompetent in Texas by a government psychiatrist as well as the defense psychiatrist. So his competency has always been an issue in this case. And I stand corrected, and I remember that now from the briefs, but still the timing difference between when you have a bunch of reports that one judge doesn't find persuasive and maybe a year, well, you said it took 2.5 years. I don't know when the second battery of tests occurred. It's just rather surprising. He was being tested from the moment he entered his guilty plea forward, and none of the people who examined him during that period of time found that he was competent. He was hallucinating, he was hearing voices, he was delusional, his affect was flat. He was clearly... How did that happen? Why, was that because of a guilty conscience? I mean, I really don't... I sympathize with Judge Hicks's position. Well, I have to say, Your Honor, that I think that this, you have to remember, only 29 days elapsed between the time that Counsel Carnes enrolled in this case and the time the guilty plea was entered. 29 days for a case of this complexity. On its face, that is ineffective assistance of counsel. No one could in good conscience take a case of this complexity with a client who had all of the problems that were known at that time and enter a guilty plea. And
as Carnes himself admitted, not even knowing that the penalty, potential penalty, was life imprisonment. Carnes was telling his client he was going to get 25 years.
Counsel, I realize your time is running short, but I have a factual question that I was hoping to resolve. So I understand the Western District of Texas grand jury returned its indictment in December of 2011 to remain sealed until your client was arrested. I understand from the docket activity in the Western District of Texas that there was a detainer lodged where your client was in January of 2012 in Bossier Parish. And I understand from the U.S. Attorney, the U.S. Marshal Service memo that appears at 1842 of the record that he, quote, was arrested on January 9th, 2012, and that the indictment was unsealed the next day, January 10th, 2012. All of these are cited in the government's brief, in its red brief on appeal, and I'm not sure I understand your response to that as to why we would think he wasn't actually on notice of the Western District indictment until 8 months later.
If you go behind the docket sheet, Your Honor, and you look at the actual record itself, the entry in the record shows that he was not arrested. A detainer was lodged with the facility where he was being kept in the Western District. If you go to document number 28, you will see in that record, you will see that he was actually arrested, and the return, this is a return from the Marshal Service. The return on the arrest warrant on the indictment is August 28th, 2012.
Right, so I saw that, and he's clearly arrested on that date. There's no doubt about it.
Right.
My question is, do you think that the Marshal Service was just wrong when they said at 1842 that he was arrested on January 9th, 2012? Do you think that's just...
Well, that wouldn't be the Marshal Service. That would be the docket clerk making an entry into the minute entry into the docket sheet that the arrest was there. But there was no arrest. What they sent out was they knew he was in custody. They just sent out a letter saying, please lodge this as a detainer.
Well, 1842 is a USMS memo that says he was arrested, so I assume you just think that's not true.
Yes, I think that's not true.
So then I guess my next question is, since the indictment in the Western District says that it is to remain sealed until he is arrested, was it violative to unseal it on the 10th of January? Because we all agree that that happened, right?
All that you have on January 10th, Your Honor, is an entry in the docket sheet that says indictment unsealed. There was no motion to unseal. There was no indication that service was made of anybody on the indictment. There's nothing other than a line in the docket sheet that says the indictment was unsealed. And Cuff did not have counsel in the Western District of Texas. So who do you serve it on?
Well, it's not, I mean, I guess it's my question to you. You're obviously the 2255 movement. So, I mean, you have a USMS memo that says he was arrested. The indictment itself says it's sealed until he is arrested. So if you add those two things together, combined with the fact that it's unsealed the next day, that seems like 1 + 1 = 2. But that's why I'm asking you the question. Maybe I'm missing the math.
Well, what you have is you've got these entries, but you don't have anything that actually conveys the fact of the indictment to either Cuff or his counsel.
But if he wasn't arrested on January 9th, it would have been illegal to unseal the indictment on the 10th, right?
I don't know.
I mean, it says sealed until arrested, so
you
know this better than me, perhaps.
But that assumes that the indictment, something actually happened with the indictment that unsealed it.
There's no reason why the indictment was sealed to begin with. I'm looking at the PSR, Mr. Larson, which is dated January 25th of 2012, paragraph 22. According to the United States government, they have no evidence that these pictures, blah, blah, were uploaded to the Dream Board. Further, the government reports there are no charges pending against the defendant as a result of this behavior, which is referring specifically to the molestation of the 5-year-old in El Paso. That's as of January 25. That's based on the government's representation. And there were no objections by the government or by the defendant. And I'm not sure what that date is, whether it's January 15th or in May, which tends to support your position.
Absolutely, Your
But
Honor.
anyway, you have time for rebuttal.
Thank you, Your Honor.
Good morning, Your Honors. Good afternoon, Your Honors. And I just wanted to appreciate your continuing this because of my health. I really appreciate it. I was going to address the first issue, which is the procedural bar issue. And basically, the defendant cites Massaro, but Massaro is very limited to ineffective assistance of counsel, and that was decided in 2003. There hasn't been anything since then citing Massaro for the proposition that you can extend the idea of not having a procedural bar for certain issues, such as a plea agreement, a breach of a plea agreement issue. So we maintain that that issue is procedurally barred. Massaro does not stand for that proposition. In fact, it has extremely limited language. It says, under the rule we adopt today, ineffective assistance claims ordinarily will be litigated in the first instance in the district court, the forum best suited in developing the facts necessary to determine the adequacy of representation during the entire trial. And then it goes on to say that ineffective assistance is the appropriate issue for this because it puts the trial attorney and the appellate attorney in conflict. So our position is that Massaro cannot be extended beyond ineffective assistance of counsel.
Well, suppose you go to what happens with cause and prejudice.
Oh, okay, then I'll, yeah. So let's say he's procedurally barred, then we go to cause. Now, Boosley and and Guerra indicate that the cause is you need to raise the issue on appeal. And here, the defendant had, by the time he filed his appeal, and as he admits in his brief, he was able to raise this issue. Just the way he raised the issue about the secret indictment, he would have been able to address the plea agreement issue.
Well, he says he raised it for the purpose of asserting that the guilty plea was involuntary, or that the guilty plea should have been vacated under Carr, right? But he did not have a basis for thinking that the government had really screwed around with him.
Well, at that point, if he was aware of the secret indictment, I mean, he obviously would have been aware of the breach of the plea agreement. I mean, they go hand in hand. I mean, they're basically the secret indictment.
What would you do to this court if you're the defendant, you pled guilty, and then you find that the government had a sort of non-prosecution agreement, but hey, it's only good for this district, and then another charge, government hasn't expressly said we're not going to charge you, but it said we're only going to charge you for what we know about right now, and then they've hidden it from you. That looks like serious. Maybe suppose it were a person who wasn't in for life. Is that something that the government normally does?
No, Your Honor. I mean, it looks like from the chronology in this case that because the government never raised that indictment in the pre-sentence investigation report, never corrected that, it looks, the
government had a duty to correct it, number one. Number two, they had a duty not to mislead Mr. Carnes, his defense counsel, about pending charges. Number three, the Western District Attorney had every reason to know who Mr. Carnes was when they charged him, and they all maintained radio silence. This sounds like January 6th.
Well, Your Honor, our position would be that the Western District of Louisiana was apparently not aware of what was going on.
I don't believe that. How can we not believe that? Because they were offering this evidence of a grotesque molestation of a 5-year-old in order to get a life sentence.
The record doesn't indicate that Mr. Carnes, The AUSA in the Western District of
We have an
Louisiana.
affidavit from the Western District AUSA.
No, Your Honor, we don't.
We have an affidavit from the Texas AUSA.
No, we don't, Your Honor.
Anything.
But Mr. Carnes never indicated that all three of them met together.
Does
And
that
the
matter?
appropriate remedy would be for...
I wouldn't either if I weren't planning to tell the defense counsel what I'm doing.
And there really wouldn't have been a reason for the Western District of Louisiana to sabotage their own case by doing something like that. So I think the record seems to indicate that perhaps...
Well, if we overcome cause and prejudice, I guess the AUSAs will be able to explain themselves.
Yes, Your Honor. And then the other thing I was going to go to, the appropriate remedy for Mr. Cuff would have been to file a motion to dismiss the indictment in Texas. He had plenty of time. When he actually, let's say, in Texas, he was...
We're not here to argue.
Oh, I know, but...
Tactics in Texas, okay? I am very leery about what the government did here. I'm beginning to lose faith in the integrity of federal prosecutions for various reasons. And this case is one reason why. But from a legal standpoint, it turns on, to me at least, cause and prejudice to avoid the procedural bar.
Yes, Your Honor. And then we would... I mean, I agree with you that the facts in this are not clear what was going on.
So what argument do you have as to whether, if there was a procedural bar, Mr. Cuff could avoid it by stating cause and prejudice? How do you...
Okay, well, as I said, my argument on cause was that on appeal he could have raised it. He could have raised it just like he raised the issue concerning the indictment. And then at the...
What would the procedural vehicle have been for that? In other words, how would he have phrased his argument to this court?
Basically the way he phrased the sealed indictment. And the other thing he could have done, he could have filed a rule under the Federal Rule of Civil Procedure 60 and asked the district court to have concurrent jurisdiction and have the issue looked at that way. He could have done that. The 60 Rule A provides that with the Court of Appeals permission, the district court can look at a Rule 60. That would have been...
Why was the indictment sealed?
I'm sorry, Your Honor.
Why was the indictment sealed?
The record really doesn't indicate that.
I know the record doesn't
No,
indicate that. Do you have any explanation for it? What was the necessity for sealing the document?
If you look at
You seal documents to keep people from knowing about it, don't you?
I think some of the concern was protecting the victim, the 5-year-old victim in El Paso. I think from some of the material that the defendant put into...
But the answer is you don't know.
I don't know. I mean, the record...
Did you ask anybody?
No, Your Honor, because...
Nobody wants to talk about this.
Well...
That's why we need a hearing to find out what happened. What do you think? Do you think there ought to be a hearing to find out what happened?
I think the whole issue's moot because that indictment was dismissed. And I don't think he would have pled guilty. He would have pled, even if his attorney would have known that, I don't think he would have pled guilty. I mean, excuse me, I think he would have pled guilty.
He entered a plea without assurance, and but that was a lie. And unquestionably, it was a lie. Somebody's lying to the court. And on that basis, this defendant is not exactly a deserving citizen, but for heaven's sakes, he is still a defendant, and he's entitled to these basic fundamental rights. I like Judge Jones. My large concern is with the conduct of the government here. And my question is that why don't we find out what happened, and then we can figure out what was going on? It's difficult to assess cause and prejudice when everything is sealed. And you don't know why, the government has no explanation for why it did it. And nobody asked.
Well, Your Honor, since there wasn't an evidentiary hearing, I don't, I mean, I guess I could have gotten an affidavit.
You personally, counsel, but the problem is, the record doesn't reflect it. It's not a complete answer. And you say, I don't know. It's just, the question of why it was sealed would seem to me to be relevant to this inquiry.
Again, all I can do is gleaning from the record, from that statement that Mr. Crumbs made to, I think, some investigator, it looks like he was probably trying to protect the victim from the defendant's family.
Well, you often identify a victim by initials, don't you?
Oh, but I think everybody knew who the child was.
What?
I think it was pretty apparent who the child was. It was the daughter of his girlfriend. I mean, I don't think, like, if the...
We just had another child molestation case today where they identified the kid was molested by his uncle, and they used initials all the way through. I don't think that's a good excuse for sealing an indictment. Is that, and you don't have an explanation for it otherwise.
No, Your Honor, I can't, there's nothing in the record that provides an explanation.
And it's not just that you sealed an indictment, it's the context in which you sealed the document. And while you're simultaneously taking a plea to the defendant, and the part of the plea of bargaining for that, to avoid a trial necessity, he didn't put you to trial. Out of this conduct or your conduct, we're not charging you elsewhere. At the same time, you were exactly doing that.
Well, again, we would indicate that the Western District of Texas and the Western...
Ma'am, I'm sorry.
The Western District of Texas and the Western District of Louisiana may not have known what they, may not have known what each other was doing. That's the only thing I can explain.
Not the Western District that I knew. I've sat in El Paso many years ago, and that's not the quality of I saw then.
They had to have coordinated precisely because, as the PSR reflects, they were using the video that the fellow had created of his molesting the 5-year-old to enhance his sentence to life. Now, you're saying somehow that the AUSA in Western Texas, after being communicated with by the AUSA in Louisiana, keeps totally mum. I mean, that just doesn't sound right to me. And, if this were, if the shoe were on the other foot and this were, what is it Brady? We rely on, there's several areas where we rely on the collective knowledge of law enforcement, and we assume that law enforcement coordinate and collaborate with each other.
In the context of plea agreements, it's a little different because a plea agreement is seen more like a contract. I mean, so I think that's how that's...
That is totally unpersuasive to me. It says, we will not prosecute you on any other information that the government knows about. It doesn't say we won't prosecute you in the Western District of Louisiana.
Okay, our position on that would be that there's a split in the circuits on that some circuits have read that to encompass just the office at hand.
Well, it doesn't sound very persuasive to me, speaking as one member of a panel.
Yes, Your Honor, and I didn't...
And there might be other factual circumstances, but here, given the fact that there was the government, the timing is so close that it's very difficult to conceive of there not having been knowledge in the Western District of Louisiana.
I mean, again, this is off the record. I asked the assistant U.S. attorney who prosecuted this case, and he said he didn't know, but that was, as I said...
But you don't have an affidavit.
I don't have an affidavit. That's just completely off the record.
Well, then
and not-
it's still a black eye on the Western District of Texas if your contract was written in such a way that it ought to cover this.
And then I double-checked, and that language that was in the plea agreement in the Western District is apparently standard language in the Western District of Louisiana. That, I wasn't sure whether that particular clause was just used back then for this type of case, but apparently that's standard language in the Western District of Louisiana to have that particular clause. So it wasn't a clause specific to this prosecution.
You said what federal rule of criminal procedure?
60, it's the Federal Rule of Civil Procedure, 60, where you could,
On direct appeal in a criminal case?
well, Rule 60 can apply to criminal
Talking about
cases.
60B or something?
Yes, and that, there's a clause that you can ask the appellate court to let the district
We
court.
can do a tentative remand whenever we want to, but I never heard of 60B being used.
I've seen that, I handle a lot of the post-conviction work in our office, and I've seen defendants try to, use that as an alternative or instead of a 2255.
Would you, if there were a cause, would you agree there was prejudice or not?
I don't think he was prejudiced because ultimately the indictment was dismissed in Texas. And
Well,
I never got to, oh, I'm sorry, Your Honor.
Well, according to the PSR, he had already lost his house, his truck, and his motorcycle. His wife was about to file bankruptcy. So if he incurred, are you saying he needlessly, do you think he was apparently represented by retained counsel in the Western District of Texas, so at least he may have been prejudiced to the extent of retained counsel?
Well, Your Honor, the way the cases look at cause, it has to be to a constitutional level, and I'm not, the defendant never articulated a constitutional violation when you spend money defending yourself. I mean, that would be a civil lawsuit against the Western District of Texas, I guess. But then, what I was going to mention about the ineffective assistance of counsel claim was if you look at the communications that the attorney had and the defendant had at the time he pled guilty, even if he had known about that indictment, there's no indication that that was a concern of his. His concern was getting less time. If you look at Lee out of the Supreme Court, what you look at is the contemporaneous understanding of the defendant. And at the time, all his statements were more like, I want to get less time, I want to get less time. He wasn't saying, oh, I don't want to be prosecuted in Texas. So we would argue that he wasn't denied effective assistance of counsel through these actions because of, if you look at the language of Lee, all the statements are after the fact. During the time, even the communications between the defendant's attorney and his sister, there was never a mention of the Texas charges. It was more like, will he get less time? And then Young has some interesting language that says, of course, when you plead guilty, you think you're going to get less time, but in Young, he didn't get less time, and that doesn't necessarily vitiate the guilty plea or make your attorney ineffective because you thought you were going to get less time. And then Lee, the difference in Lee, where there was an ineffective assistance of counsel, the defendant kept on saying, I don't want to be deported, I don't want to be deported, I don't want to be deported, through the whole thing. So the fact that the attorney didn't tell him that he was going to be deported was ineffective assistance of counsel because that was out front. But you don't see that here. You don't see, even under oath when he pled guilty, he just said, oh, I want to go to trial to avoid less time. He never said, I want to plead guilty because I want to avoid less time. I know if I went to trial, I'd be convicted. He never said, oh, I want to plead guilty because I know I'm not going to be prosecuted in Texas. He never said that. So we would say that that's the distinction between Lee and the case here. And Young versus Springer coordinates with our position.
Well, of course, the guilty plea contract said, we will not prosecute you for the government will not prosecute you for other conduct of which it knows.
But then the remedy there is to cure the breach, and it was cured. I think it's Purser indicates that when there's a breach, you cure it. And the way you cure the way it was cured was the indictment in Texas was dismissed. Maybe not intentionally, but it was dismissed. I mean, intentionally because, and again, the record doesn't indicate why the indictment in Texas was dismissed. There's no reason, it just was dismissed.
Okay.
Thank you, Your Honors.
Judge Higginbotham, to answer your question, the indictment was sealed for the basic reason that the government wanted to hide it. They did so in their motion to seal the indictment. The government stated, and I quote, "The disclosure of the existence of the indictment would seriously jeopardize the ability of law enforcement officers to locate the defendant and apprehend him without incident." He was in jail, and they knew he was in jail. That was a lie, flat out. They made a lie to a federal judge. I know U.S. attorneys have been disbarred for that. That's what they did. And Judge Oldham, you asked about the arrest warrant. The indictment was to remain sealed until the defendant was arrested, not detained, arrested. And if you look at document number 28 at the bottom, it's signed by the U.S. Marshals Service saying he was arrested, not detained, on August 28th, 2012. The reason Robert Cuff never mentioned the Texas charges in his communications with his attorney is because he didn't know of their existence. And he didn't mention them because he didn't think he was going to be prosecuted for them, because his attorney had talked to Brandy Gardis in the Western District of Texas, who assured him that there weren't going to be any Texas charges.
What do you ask this court to do?
I'm asking this court to remand this case for an evidentiary hearing so I can question Brandy Gardis, Luke Walker, the U.S. Marshals Service, and a variety of other people under oath regarding what happened in this case. The prejudice is very simple, Your Honor. It may seem like, oh, well, we're going to end up at the same place. He's got a life sentence. You know, how could Texas have possibly changed that? That can't be the test, Your Honor, because what that would mean is that anytime somebody was serving a prison sentence, if they were charged with something else that would have given them concurrent time or an equivalent sentence, you didn't need to defend against it.
That's not, well, obviously that's not so, because the judge always has the option to run sentences consecutive.
Obviously. And what this case is about preserving the integrity of the judicial process. Everybody in that courtroom in the Western District of Louisiana had a duty to make sure that Cuff's plea was knowing and intelligent and voluntary. And the defense attorney and the court could not fulfill that duty because of the government's duplicitous conduct. That's what this case is about. And I would urge the court to remand this for an evidentiary hearing, although quite candidly, I think that there is enough evidence on the record to demonstrate that there was a knowing, willful, and intentional violation of the plea agreement, and to remand it basically with instructions to vacate the guilty plea.
What the old saying is, the most powerful disinfectant sometimes is a little sunshine.
And that's what's needed here, Your Honor.
All right. You have your argument. Thank you.
Thank you.
Court will be in recess.